Okay.
She's gone missing.
We take the source documents, legal filings, research, internal memos, and we pull out the insights you need to understand the real story.
And today's story is, well, it's an intense one.
It really is. Our mission today is to get inside a high-stakes filing in the Supreme Court of India. It alleges that the state of Punjab is actively hiding a key police record.
And that this suppression, this act of hiding a document, is putting a citizen's life in immediate danger.
Our source material is a writ petition. This is diary number 72596-2025. It's filed by a petitioner named Push Sharma against the state of Punjab.
And it's filed directly under Article 32 of the Constitution.
Okay, let's unpack that. For anyone not deep in Indian law, Article 32 it's the constitutional nuclear option, right?
It is. It's the extraordinary jurisdiction. You go there when you believe your fundamental rights are being violated right now, and you need the highest court in the land to step in.
Specifically, we're talking about Article 21, the right to life and personal liberty.
Precisely. And the claim isn't about some subtle legal argument. It's about facts. The petition claims that multiple orders from the Punjab and Haryana High Court were built on a factual premise.
A story the state told the court.
Exactly. A story that the state's own internal records, their own paper trail, flatly contradicts.
So the allegation is that the state made an incorrect statement in court, and that statement led to this petitioner being denied protection. Our mission is to trace this chain of events. How did a journalist and a witness end up having to go to the Supreme Court to protect himself from the state?
To get the gravity of this, you have to understand who the petitioner is. Push Sharma. He's an investigative journalist, a law student, and this is the critical part. He's an informant and an assisting witness.
Not in just any case.
No. In the Supreme Court-monitored Faridkot sacrilege case of 2015.
That immediately raises the stakes. This is one of the most sensitive, politically charged investigations in recent memory in Punjab. We're talking about the desecration of the Guru Granth Sahib, which led to huge protests and massive political fallout.
And the information he has is international. The petition states that between 2018 and 2023, while he was working in London, he got his hands on foreign investigative material.
Material connected to whom?
Nirav Deepak Modi. And crucially, it included information touching on the funding trail behind those sacrilege incidents.
Wow. So this isn't a local issue. He's holding internationally sourced evidence related to a massive case. And the courts knew this, right?
They did. On December 19, 2022, the Delhi High Court formally accepted these documents. And these were apostilled documents.
Wait, apostilled? What does that mean in practical terms for our listeners?
It means they've been internationally authenticated under the Hague Convention. They aren't just photocopies, they're verified form public records. They carry serious weight.
So the court took them seriously.
Very seriously. The Delhi High Court didn't just accept the papers. It went on record acknowledging the severe threat the petitioner was under. They even granted him relief, like letting him join proceedings by video from London. His life was considered in danger long before he even returned to India.
And the timeline here is tight. The petition shows that on May 8, 2025, these same UK records were placed on file in the main sacrilege trial in Chandigarh.
Right. And he'd returned to India a couple of years earlier, on January 10, 2023. Knowing the kind of information he was carrying, he did what anyone would do. On May 23, 2025, he formally asked the state for security.
And this is where the story turns.
This is the catalyst. Just over a week later, on June 1st, 2025, he was physically attacked, hospitalized.
That sequence is just chilling. He asked for protection, and then he's assaulted. It validates everything the Delhi High Court had already recognized.
Absolutely. And this attack is what kicks off the entire legal battle we're looking at. It brings us to the central factual disconnect, the whole basis of this writ petition.
The story the state told the court.
Yes. When the petitioner went to the Punjab and Haryana High Court for protection after the attack, the state repeatedly told the court something very specific. In July, in August, in September 2025.
What did they say?
They said the petitioner had not approached the respondents with any grievance regarding threat to his life after the physical attack.
They told the court he never followed up, that he was attacked and then just did nothing.
That was their submission.
But the source material, this petition, says otherwise.
It points to a direct, documented contradiction. The petition includes official police documentation from June 18, 2025, less than 3 weeks after the attack.
And what is this document? We need to be specific here.
It's what you'd call the smoking gun. It's Annexure P6 in the petition. It shows that on June 18th, the petitioner personally went to the office of the DSP in Zirakpur.
He went in person.
Yes. And his representation, his request for security, was formally diarized. It was given diary entry number 4045 SSSP. It has an official seal, a signature, a date. It's undeniable proof that he did approach the police.
So the single most important fact in the case, did he ask for help after the attack, was being denied in court, even though the state's own files, their own sealed record, proved he did.
And that's the core issue. This diary entry, this proof, was never shown to the High Court during those hearings.
It was suppressed.
The petition argues it was. And because it was withheld, the court's reasoning was based on a falsehood. And that falsehood became the foundation for multiple court orders denying him protection.
So he's trapped, denied protection based on a lie that the state itself could disprove at any moment. This is a violation of Article 21, right to life, based on a factual error.
An error that created, and I'm quoting the petition, a continuing prejudice against him.
The story then gets even more dramatic in September 2025. It sounds like the state machinery started to collapse in on itself.
It's an astonishing moment. On September 4th, the Office of the Governor of Punjab, the highest executive office in the state, orders an inquiry.
An inquiry into what?
Into an apparent fraud upon the court. That's Annexure P8.
Hold on. The governor's office is investigating the state's own lawyers for potentially committing fraud on the High Court in a matter of life and liberty.
That's what the document says. It's an institutional crisis. One part of the executive is essentially saying, we think our own legal team misled a judge.
Incredible.
And it doesn't stop there. The very next day, September 5th, another official communication. This time from the Bureau of Investigation, the Punjab Police. It confirms they've taken up the petitioner's complaint about the state's misrepresentation for action.
So you have this paradox. In court, the state is saying, he never approached us. But behind the scenes, the governor is investigating that statement as a possible fraud, and the police are processing a complaint about it.
The two positions cannot logically coexist. It's a complete contradiction.
And the petitioner's caught in the middle of this. He has the proof, that diary entry, but what happens when he tries to use it?
This is where the pressure becomes direct and, frankly, terrifying. On September 8th, right after a court hearing, a state representative allegedly warns him.
Warns him about what?
That if he dares to use that police record diary entry 4045 to prove the state was wrong in court, he could face charges under the Official Secrets Act, the OSA.
The Official Secrets Act. So they're threatening him with a colonial-era law that carries severe prison time for disclosing official information.
Exactly. It's the ultimate chilling effect. He has the one piece of paper that proves his case and secures his right to life. But if he uses it, he could go to jail.
It's an impossible choice. Protect your life or protect your liberty.
And the pressure worked. On October 16th, facing the threat of heavy court costs, and the state arguing the matter was already decided, res judicata, he felt he had no choice.
He withdrew his petition from the High Court?
He withdrew it. The sources say it was under coercive circumstances, because the very orders that were being used against him were the ones based on the suppressed facts in the first place.
Which brings us full circle to the Supreme Court. He's not appealing the High Court's decision in the usual way. This is something different.
Yes, this is a direct plea under Article 32. He's not asking the Supreme Court to just review the law. He's asking for immediate constitutional intervention to stop a continuing injury.
So what's the specific legal remedy he's asking for?
He's asking for writs of certiorari and mandamus. But it's how he's using certiorari that's so specific here.
Okay, let's break that down for our non-lawyer listeners. What does that mean in this context?
He's essentially asking the Supreme Court to perform a kind of institutional decontamination, to officially declare that any judicial observation built on the state's falsehood, on the denial that diary entry 4045 existed, is void.
So it can't be used against him anymore.
Precisely. The goal is protective, it's forward-looking, it stops the state from continuing to rely on a judicial record that its own files have now proven to be false.
It neutralizes the poison from the system, so the state can't keep denying him protection based on that original false claim.
Exactly. And he's not just making this up. The petition cites established law, a case called A.V. Papaya Sastry. It's a foundational legal principle that fraud or misrepresentation undoes everything. A judgment built on a falsehood can't stand.
So that brings us to the core constitutional argument, the big takeaway for the Supreme Court.
And it's a powerful and very focused argument. It boils down to this. In matters of life and personal liberty, the state cannot rely on prior judicial observations, founded on representations that its own records no longer support.
It's a demand for basic integrity. Correct the record to reflect the truth and restore his fundamental right to protection.
So this whole deep dive, it shows how one single document, a police diary entry, became the center of a Supreme Court battle.
Yeah.
It exposed this massive contradiction inside the state's own machinery.
And all the while, a citizen's life is hanging in the balance.
And the sources confirm, as of December 10th, 2025, that constitutional injury is ongoing. He's still without effective protection. He's at risk not just from the people connected to the case, but from the state's own hostile legal stance.
It's incredible. So the ultimate question this deep dive leaves us with, and we want you to really think about this, is when a factual error in a court record is so clearly disproved by the government's own files, not some disputed evidence, their own signed, sealed record, how fast must the system act to fix it, especially when a person's fundamental right to life is on the line?
That need for immediate correction, for a systemic fix when a life is threatened, that is the very reason Article 32 exists in the Constitution in the first place.
Black Letter Media.
And with no end in sight to this wave of crime.
इतना टाइम हो गया है अभी भी हमारे जख्म ताजा हैं.
The sting operation videos confirm that the Crusader is a criminal who targeted ministers for money.